time and place of the 4 alleged incidences that have been charged in this case. So the state has to pick one or the other. They're either going to accept that the witnesses' statements are credible, or if not, then we should be having an evidentiary hearing where they can be subject to cross-examination, and the state can then make a showing to the court, or attempt to make a showing to the court, why they are not credible.
We don't have a rule to cover this express situation. We have a Simpson hearing rule, which tells us to go look at a prelim. This is not exactly that, but in the prelim situation, it says that the defense may make a specific offer of proof, including the names of witnesses who would testify or produce evidence, and the magistrate would allow the defendant to present that offered evidence. I read that to be in a hearing setting, so there would be cross-examination. But I do not believe I have the authority to allow over objection telephonic testimony. So it becomes a management decision on your part whether you want to do it by proffer or present live persons.
Judge, an alternative option for the witnesses that are out of state, we could provide the court and counsel with a sworn affidavit from those witnesses that would serve, I think, our purpose, the defense's purpose, and then I guess it's up to the state to decide what they want to do with that. Again, we invite them to cross-examine those witnesses if they like, but we can certainly present sworn affidavits.
Mr. Leiter.
It seems like that is, if they're comfortable, then with sworn affidavits, then we don't in fact need an evidentiary hearing. That was the information that I was under the assumption that they were going to provide as a proffer to the court. Essentially, defense counsel wants us to jump a couple of steps ahead and go to trial and do the trial already, and that's not what the proper. This is not the proper forum for that, Your Honor.
Judge, with all due respect, I think it is. I think what's hanging in the balance is whether Mr. Merritt's release conditions will be modified or not. I think it's very important for this court not just to hear from the attorneys, but to hear from those individuals who were present either in person or by phone at the time of the alleged shootings. Those people would say that Mr. Merritt was either with them or on the phone with them. There is cell site information that corroborates that Mr. Merritt was not at these alleged locations on the time and date. And there are phone records that corroborate these witnesses' information. So I think it is important for the court to have all of that information, but I think it's important for this court to hear from those witnesses specifically. And again, I mean, this is a little bit strange because we are inviting the state to test this information, and the state, for whatever reason, is deciding they don't want to test this information at this point. So I think the evidentiary hearing is proper, and the 2 out-of-state witnesses will be happy to provide affidavits.
Okay. Knowing that my job is to look at the views of the victim, the nature and circumstances of the offense, the weight of the evidence against the accused family and employment ties to the community, any drug test results, the accused's length of residency in the community, the accused's criminal history, and the accused's history of making prior court appearances. I will set that for a hearing. It sounds like it's more going to be oral argument than testimony if we're not going to have live testimony, which is fine.
Well, we're willing to concede, since the court isn't willing to allow telephonic, those 2 out-of-state witnesses were willing to concede through affidavit their statements. However, we do have witnesses that would be present that are in state, and we would like to present those witnesses to the court.
Okay.
All right. That's it.
The court will require that the parties confer. so there's no misunderstanding about who's coming or who's not coming, that the parties share with the court and with each other by the 13th any materials that either party wants me to consider with respect to making a decision on this motion to modify. And with the party's permission, I will have reviewed that before the 16th. Mr. Leiter, is that okay with you?
Yes, sir.
Mr. Farragut?
Yes, Your Honor. Your Honor, I'm not sure how much of a difference it'll make in a case like this. We did ask for the standard bond report from pretrial services.
I will order that and ask that that be given to counsel before the 13th.
Thank you.
Anything else? I know that the state intends to file a formal pleading tomorrow. Anything else for now, Mr. Leiter?
Just so I understand the court's ruling, the defense is to report specifically who will be attending the hearing. Is that
Whatever information they want to provide, if it's going to be in the form of affidavits, that you get a copy of those at the time I get a copy of those. If they're going to call John Smith as a live witness, what the topic of that would be, so that you have some idea of who's coming to challenge the state's proffer. Also, what's unusual is that you argue against the mini trial, but I think it's appropriate under these circumstances that you be allowed to have a rebuttal case, which is what I'm also requiring the defense to give you a heads up of what their case is, so that whatever rebuttal information you have, you can have a chance to present it.
it seems to the state, Your Honor, that the time the court has carved out for this hearing, we can't, if the defense is in fact allowed to call witnesses and the state's allowed to cross-examine those witnesses, which again, for the record, the state does not believe is appropriate. The defense is entitled to do so, that they can make either the proffer they've already made or via affidavit as they intend to without state witnesses. The state believes that at least we should be able to speak to whoever the defense bringing to the hearing on the 16th.
Any requests for Rule 15 interviews can be done after by both parties. This is just a preliminary decision. And in order to focus that, Mr. Leiter, I will ask, I don't know if you're prepared to answer now or you want to put it in the pleading. I have read the charges. I understand the charges, but in terms of putting it in the context of the defense pleadings, I would guess that each of these has a geographic place and a time. You have in mind when and where these alleged acts occurred.
So the court understands, and I understand the court has very little information about the actual facts of the case. There are 4 separate incidences that occurred, 3 of which occurred on August 29th, 2015. The other incident occurred, as stated in the indictment, between August 22nd and August 27th. And just so the court is aware, I will structure my response such that I will structure it per the incidences so the court can connect the specific charges with the specific date and geographic location.
All right, and then to both parties, to expedite that hearing, I'm just focusing on if this is a purported alibi. I don't need the history of each one of these witnesses. I want to know where they were at 7 a.m. or whatever time it is on August 29th. So we'll limit it to that. Anything else, Mr. Leiter?
No, Your Honor.
Mr. Farragut?
2 things, Judge. Number 1, the state mentioned that they had some information that they would use to challenge the veracity of those witnesses. We haven't received that information, so is that going to be due by the 13th of November?
Anything that you guys want to give me, you are to share with each other before the 13th. If I get it before, that's great, but I would love it on the 13th, so I have something to do for the weekend.
The other thing, Judge, is on the 13th, we do have an IPTC in front of Commissioner Bernstein. I would ask that we vacate that.
I'll vacate that and we'll combine our hearing with that IPTC.
Judge, in fact, I think we may even have a complex management conference in this division on the 17th, so would it be fair to vacate everything except the hearing on the 16th? We'll do it all together.
That'll work.
Great, thank you.
And the other question, just procedural, Mr. Lamb, do you want it to start at 1, 1:15, 1:30?
Judge, I'd like to say 1 o'clock at this moment, but if we could communicate informally with your division, let me see if I can move my flights around that morning just a little bit, and I'll get working on that no later than tomorrow.
Okay. Mr. Leiter, does it matter to you?
No.
Mr. Farragut?
Okay.
All right, just give us a quickest heads up so we know when to bring Mr. Merritt. Anything else, Mr. Farragut?
No, thank you.
Lamb?
No, sir, thank you.
Mr. Leiter? Ms. Losico?
No, thank you.
All right, thank you. We're adjourned.